When facing criminal investigation or prosecution, one of the most effective tools us criminal defence solicitors use is the use of written representations. Today, we'll be discussing what written representations are, when they can be submitted, and how they can assist you in your criminal matter. Written representations are formal submissions prepared by your solicitor that set out legal and factual arguments on your behalf. They can challenge the strength of the evidence, highlight procedural errors and breaches of your rights, present mitigating and/or public interest factors, and even persuade the police or Crown Prosecution Service to reconsider their position entirely and drop the case. When reviewing representations, the police and Crown Prosecution Service apply what we call the full code test. Now, there are two parts to this test, the first being the evidential test. This test is to see whether there is sufficient evidence to provide a realistic prospect of conviction. The second test is the public interest test. Even if the evidential test is met, is it in the public interest to prosecute? Factors in this test would include the harm to the victim, the culpability of the suspect, and the whole community impact. Pre-charge written representations occur after the initial police station interview. After this interview, the police may consider sending your file to the Crown Prosecution Service for a charging decision. This stage of the matter is critical. If there are any weaknesses in the case, or if there are any strong reasons why a prosecution in general would not be in the public interest, written representations can be submitted before any charging decision is made. An example of a good pre-charge written representation includes pointing out the gaps or inconsistencies in the evidence, explaining why prosecution would not meet the CPS's charging tests for sufficient evidence or public interest. A well-timed pre-charge representation can stop the case dead in its tracks, sparing our clients the stress, expense, and publicity of a formal charge. Even if your case proceeds to a charging decision, it is not always the end of the matter. Written representations can still be used to persuade the Crown Prosecution Service to either discontinue the proceedings or reduce the charges to a lesser offence at court. You may be asking, why do these representations even matter? Written representations are not just a simple piece of paperwork. When drafted properly, they can prevent weak cases from even reaching the doors of the court. They can save our clients unnecessary stress and even reputational damage, and secure a more favourable outcome even after charges have been laid previously. At Britton & Time Solicitors, rather than waiting for matters to escalate, we intervene early with persuasive and well-structured written representations designed to protect our client's position at the earliest stages.